Hi, my name is Max Frizalone, and I'm a Maryland criminal defense attorney. Today, I'm going to be talking about domestic violence charges and how our firm can help you fight them. If you or someone that you love has been recently charged with a domestically related crime, you may be scared, afraid, and unsure of what might happen next. In this video, I'm going to talk a little bit about what a domestically related offense are, what are some of the common ones we've seen, what are the potential penalties, and then how we fight those offenses in the criminal realm when it comes to a criminal charge, or in the civil realm when it comes to a protective order. So first, let's jump into what is a domestic crime, right? What is a domestic violence offense? What is a domestically related offense? Under Maryland law, there is no specific domestic assault crime. However, an allegation of a second degree assault, which could be hitting somebody, for example, will be domestically related if the person you're alleged to hit is a girlfriend or a family member. The same applies for other crimes. And then there are some crimes which are always going to be domestically related. And by those, I mean something like a violation of a protective order, because a protective order requires the other party be, someone you're in a relationship with or someone you're related to. Therefore, any violation of that order will automatically be domestically related. So, what does domestically related mean? It might mean additional collateral consequences. It might mean a longer expungement period, for example. What it usually does not mean is a harsher penalty. There's no enhancement necessarily for a crime being domestically related, but there could be additional collateral consequences when it comes to try to expunge it, for example. So, what happens after arrest for a domestically related offense? The same thing that happens with any other type of criminal offense, right? You're probably taken into custody, unless you're given a summons, which doesn't happen often in domestic cases. You're taken into custody, and who is the first person you'll see? You'll see a commissioner, not a judge, but kind of like a judge. A commissioner, it works at most detention facilities. They work 24/7, meaning they're going to be there if you're arrested on Saturday night. They'll work over the weekend, and their job is to do an initial appearance. They got to inform you of your charges, your right to counsel, collect some basic information about you, and then set an initial bail amount if they're going to set one, or hold you, and then you're set before a judge. And a lot of domestically related offenses, the commissioners do err towards holding people because when you hear something's domestically related, you always assume there's just a higher likelihood that the parties involved in the case are going to see each other again, whether they're spouses, family members, they might live together. So it's often common to see people held for a domestic assault where you might not see them held for let's say, a stranger assault occurring outside a bar. So, if you're held by a commissioner, what happens next? Well, the next available court date could be the next day, or it could be, the following Monday. If it's a weekend, you're going to see a judge. And a judge has a lot more tools in his or her chest to set a bond. Additionally, you're more likely to have the ability to have an attorney. You can have one for the commissioner. It might be hard to find an attorney at 12 o'clock at night on Friday night. Whereas, Monday at 1 o'clock for that bail review, or Monday at 10, depending on what county you're in, you should be able to find competent counsel to represent you. And often judges do set bails in domestically related offenses, as long as you don't have a history. But they might include some required monitoring, for example, like an electronic monitor. Additionally, very common thing I see in domestically related cases is some sort of stay away order being part of the bail condition. So whether the other side, your spouse, your family member wants you held or wants to proceed, sometimes people wake up the next day, they don't want to go forward at all. Is very common for judges to say no contact, right? Whether the person has a protective order or not, no living together. They want you to stay apart. Now, some judges will allow you to stay together and have no unlawful contact, but it's more common that we see no contact orders as a condition of release for a domestically related case. So if you're watching this video and your spouse or a family member or friend or whoever you're seeking counsel for or legal advice for is going to have a bail review, you may want to try to find an alternative address that does not include the place where the alleged victim resides. Penalties here, we'll jump into penalties now. Second degree assault has a maximum penalty of 10 years in jail and a $2,500 fine. That's quite a high maximum penalty. Having said that, most offenders don't receive the maximum, obviously. But you do see a lot of cases in the domestic realm where someone's charged with both first and second degree assault. So, first degree assault being a felony has a much higher maximum penalty. You're talking 25 years. And in a lot of domestic assault cases, the first degree assault is going to be based on strangulation. And police will often charge that. And then, the state's attorney's office for the county where you're your family member or you may be charged, will review the case and see if they think they want to proceed on the strangulation theory, which would require the case to go to circuit court, or if they want to dismiss that felony and leave the misdemeanor second degree assault on. And many times that will depend on, two things in my experience at least. One is the degree of the injury, right? So if you have someone who's very obviously strangled, and then is evaluated by, for example, a forensic nurse examiner at a hospital who's able to use alternative light sources to make the injury to the neck more pronounced, or if you have a petechia, which is bursting blood vessels in the eye, and you have the dramatic bloody eyes that you sometimes see in strangulation cases, that might make the state more inclined to go forward. And then the second thing, this is kind of a two-part one here, is going to be one, if you have a prior case involving the same person, and then, obviously the level of cooperation they're going to get from that person. So that might be a good segue to our next section, which is how do we fight these cases? So I would say that a good portion of domestic violence cases involve an alleged victim who might not want to proceed, because very often people are tied together by marriage, children. They don't want to tear their family apart. You get the idea. And sometimes, you end up on the other side of the case, and it almost feels like two on one. The alleged victim and your client both want the same thing, the case to go away, and the only person driving the case might be the state's attorney's office. Now, you have to be very careful as a defendant and as a defense attorney in these DV cases because you don't want to tamper with a witness. You don't want to tell someone how to get case dropped. You don't want to tell someone not to show up to court. You don't want to tell someone what to testify to. We typically advise victims get their own attorneys. We advise them to speak to another attorney outside of our law firm to insulate us from any allegations of wrongdoing. So as a matter, of course, how do we fight the case? Sometimes we leverage what we know about the victim's wishes, right? A lot of these cases involve self-defense. We've got a whole, another video here on YouTube if you want to watch it about self-defense. It's very common in DV cases. It's a complete defense to assault. So, if you're able to generate it in your defense case, and the state has to prove it wasn't self-defense, and you can watch a video on that if you're interested. A lot of domestic violence cases don't have a lot of evidence. Sometimes we're in there arguing about a scratch on an arm. Some cases involve serious injury. Some cases involve almost no injury. And the charges are often the same. And then finally, we always challenge the other, the state's primary witness's version of the events, and especially as it changes. So Maryland criminal cases, we don't get depositions, so we don't have an opportunity to cross-examine somebody ahead of court in every case. However, the initial report on 911, the report to police on body-worn camera, any inconsistencies there, and then knowing those well, and then hearing their testimony in court, and if there are any additional, inconsistencies, pointing those out to judges and juries can be very influential. The last thing I'm just going to talk about really briefly is protective orders. Often criminal charges and protective orders come around the same time. You get a domestic assault case, for example, with your girlfriend, and then she goes to the commissioner at the advice often of police and files a protective order. And how do we respond to those? There's, some times where you may want to consent in order to have no finding of violence, and there's other times when the stakes are high enough that you may want to challenge that protective order, and that might be your opportunity, your only opportunity, to have that alleged victim under oath and to be cross-examined about what the allegations are. And later, that testimony might be very important in your defense case. So if you have a case here in Maryland, we would be happy to help. The worst thing you can do in a DV case is wait. So it's oftentimes it's about the fast and early decisions in a case. And if you have a case or someone you love have a case in anywhere in Maryland, but generally in any county where we have an office, we'd be happy to help. Good luck.